Hello, I'm Danny Sullivan, a forensic psychiatrist and one of the directors of the Sentencing Advisory Council of Victoria. Thank you for the kind invitation to present on behalf of the Sentencing Advisory Council. I'm going to provide a brief overview of the approach taken to sentencing of mentally disordered offenders in the state of Victoria, Australia, which are also increasingly used in other Australian jurisdictions and possibly in some Pacific nations. In the case of the Queen and Verdins, Buckley and Vaux, the Court of Appeal of the Supreme Court of Victoria reconsidered the impact of mental disorder falling short of insanity upon sentencing and applied this to the three named cases, which are now commonly referred to as the Verdins principles. I attach here a QR code which will take you to the sentencing comments as provided on the Ostly database. Verdins principles refer to the impaired mental or intellectual functioning of offenders. In contradistinction to preceding precedents, actual diagnostic labels are considered, and I quote, the beginning and not the end of the inquiry. Furthermore, it was stated, what matters is what the evidence shows about the nature, extent and effect of the mental impairment experienced by the offender at the relevant time. That relevant time may be at the time of the offence, but also takes into account how impaired mental functioning may impact their experience of imprisonment. As noted, expert evidence should characterise the nature, extent and effect of mental impairment upon the offender at the time of offending or in the future, and must take into account the circumstances of the offending. Not only does the evidence rely upon characterisation of the impairment of mental functioning, but it is individualised and contextualised. Even if uncontested, the court need not accept the evidence, and it may give it only limited weight if the author of an expert report is not called to give evidence. Because expert reports frequently are based upon self-reported information and may be self-serving, the court must be cautious in accepting that the Verdins principles have been enlivened. The sentencing judge is expected to explain clearly in sentencing comments the way in which impairment has been taken into account in the sentence handed down. From the perspective of an expert witness, the principles are helpful in forming and framing an opinion, in providing a report, and in providing oral evidence. Not only do they require that the expert provide a clear factual basis for their opinion, but they must then provide detail about not only diagnosis, but its causal association with offending and how it is that that was relevant. Consequently, experts must have familiarity with prisons, with treatment interventions, including offence-specific programs, and have an understanding of the practicalities of treatment in prisons. Cross-examination frequently accepts the diagnosis but challenges its association and relevance. Thus, empty claims and sweeping statements are difficult to sustain. These statements, as set out in the judgment, demonstrate the ways in which an expert is expected to link a causally associated mental impairment with the sentence and to suggest to the judge how it is that the mental impairment may have affected their offence. The Court of Appeal identified that mental impairment may be relevant to sentencing because of the following reasons. Firstly, it may reduce an offender's moral culpability and so affect what is considered to be a just punishment and lessen the need for denunciation. It may have a bearing on the kind of sentence that is imposed and the conditions under which it should be served. General deterrence may be moderated or eliminated as a consideration depending on the nature and severity of the offender's symptoms and the effect of their impairment at the time of their offending, sentence or both. Specific deterrence may be similarly moderated or eliminated in the same circumstances. The existence of an impairment at the time of sentencing or its reasonably foreseeable recurrence may mean that a specific sentence may weigh more heavily on that offender than it would on a person who is in normal health. And finally, if there is a serious risk that imprisonment will have a significantly adverse effect on the offender's mental health, this will also be a mitigating factor. The principles are not applied routinely as some form of checklist, but must be invoked typically by the defence, and the onus is on the defence to prove their relevance, generally through the introduction of expert evidence. The principles are not expected to be a checklist and are not exclusive. That is, there are many other ways in which impaired mental or intellectual functioning may be considered relevant out with the listed principles. Moral culpability is considered reduced when it can be shown that intellectual or mental functioning impacts upon judgment, the capacity to think clearly and make calm and rational choices, and appreciate the wrongfulness of the conduct. It may also serve to disinhibit the offender, obscure the intent of the offence, or contribute directly to it. The causal connection is a critical element of Verdins. It's also considered, however, a matter of degree, and the court should consider the gravity of the offending and factors which go to the extent of contribution of impaired mental functioning to the offending. That is, even if an impairment existed at the time, there must be demonstrated a realistic connection with the offending. The sentencing judge may moderate any mitigation or reduction of culpability. For instance, where the offender was fully aware of the nature and gravity of what they were doing and its wrongfulness. So features such as the planning of offending or avoiding detection may reflect such knowledge. General deterrence may be moderated or eliminated, as has been said, even without a causal relationship between the impairment and the offending. The factors which are taken as relevant to moderation or elimination of general deterrence through mental impairment depends upon the nature and severity of symptoms exhibited by the offender, their impact upon the mental capacity of the offender, and the nature and gravity of the offence. Specific deterrence may also be moderated if they are able to appreciate the wrongfulness of their conduct and are considered capable of learning for the experience of punishment. Consequences of imprisonment may be relevant if the mental impairment will cause imprisonment to weigh more heavily upon the mentally impaired offender compared to other offenders. Expert evidence, therefore, may assert this, but in general there is a requirement to demonstrate more specifically why the incarceration will weigh more heavily upon them, not simply due to other factors contingent upon incarceration, such as stress or unhappiness. Conditions such as being held in isolation, protective custody, or limitations on custodial placement may also be relevant, as is the potential of significant deterioration in mental health which may be caused by a lack of availability of specific treatments in custody or the locations in which the offender is placed. However, this does not simply apply to unpleasant and unwanted effects of incarceration or stress at its prospect. Because mental and intellectual impairment may impact upon community protection, this may also be taken into account by a judge. For instance, if a person has ceased their medication or engaged in substance use which has led to reoffending and they had knowledge that it might do so, this will be taken as relevant. The presence of mental impairment may increase the relevance of rehabilitation as a primary consideration for sentencing purposes and therefore impact upon the type of sentence, its duration, or the non-parole period. In general, mental impairment which is self-induced, such as by drug or alcohol use, is unlikely to mitigate if the person had foreknowledge of the possibility of mental impairment arising from substance use. In fact, this may be taken as aggravating. And relapse of pre-existing mental impairment won't necessarily be taken in general as mitigating if the person has failed to take prescribed medication. But moral culpability may still be reduced if it's demonstrated that factors beyond their control impacted upon their relapsed mental state. This is the Supreme Court of Victoria. Since the development of the Verdins principles, Precedent has further refined their application. In recent years, the principles have come to apply to personality disorders, which were previously excluded from the framework by contrasting precedent. A personality disorder does not necessarily demonstrate impaired mental functioning, but continues to rely upon expert evidence demonstrating a causal association between features of the personality disorder on mental functioning at the time of offending or its impact upon incarceration. In many cases in which personality disorder has been accepted as reducing moral culpability, there has also been judicial comment upon the impact of the personality disorder on community protection. These terms should be raised by counsel with a sufficient evidential basis. The court is not obliged to inquire into the evidence or to consider it if counsel does not seek to rely upon it. The standard of proof is the balance of probabilities. Judges report that the Verdins principles assist in constructing an appropriate sentence and help them to take into account impaired mental or intellectual functioning without derailing their sentence or overriding the need to take into account the multiple purposes of sentencing. That concludes my discussion of the Verdins principles. Should you have further questions, I do encourage you to email me on the contact details below. I wish you the best for the remainder of your conference.